we talked a little bit about how we hold corporations accountable, being able to sue them, and that's very important. But the corollary to that is, especially when you see administrations like the ones we have now that are rolling back regulations. So they are either stopping the enforcement of laws and regulations or rolling them back. Corporations are taking advantage of that, and they're doing the absolute minimum that they have to do in order to comply with the law, which makes all of us a little less safe. And so we wanted to make sure not only to hold the corporations accountable, but by holding corporations accountable, we also want to send a signal to government as well, that you can't simply make the water that we drink, the air that we breathe, less safe and expect there to simply be no consequences for that. So it's about holding both government and corporations accountable for wrongdoing. So now we'll talk a little bit about medical malpractice, and if you don't know what that is, you will find out a lot more in about 30 seconds. Philip G. Peters is the Ruth L. Halson Professor of Law at the University of Missouri. He's taught there since 1986, and he teaches education, reform law, health law, and torts. Phil began his career in the Civil Rights Division of the Department of Justice, and then spent several years in private practice. He was also executive director of First Chance for Children, which is a local nonprofit organization dedicated to reducing economic disparities by improving the start that low-income children get before entering kindergarten. And Professor Peters' current research interest is in the identification of educational reforms with greatest potential to reduce achievement disparities. So ladies and gentlemen, please welcome Phil Peters.
First, I want to thank Ken for being the first speaker after lunch. That's the dreaded spot in any conference calendar. I thought I'd help out a little by wearing a bright tie, keep you guys awake. And I also want to thank one more person. It's really an honor for me to be invited to this. I've been an admirer of Ralph Nader and I'm old enough to have read Unsafe at Any Speed. It's been a long time and a lot of good things have been done, and thank you. Really appreciate it. Like Ken, I'm an unusual invitee. While he was not a lawyer, I was a defense lawyer, which I think puts me in something of a small group, probably here in the audience. I did civil rights work at first, and then as I followed my wife around, who's a physician, and she was doing her training around the country, the jobs I got were at defending med-mal and product liability cases. And as a law professor, some of the articles I've written have been republished in defense lawyer journals and in the conservative journal Regulation. But during all of that practice and teaching, my practice was to do what a good lawyer should do, which is to follow the evidence. And in medical malpractice law, I had a real reason to be interested. I'm married to a physician. My older daughter's in medical school. I had a real reason to try to see exactly what's happening. As you all know, there's lots and lots of attention in the press every 10 years or so about the problems in the medical malpractice system, and I wanted to have a better idea of what the evidence was. And it turned out that because this is an important field in our economy and in our well-being, and because it's politically important, physicians are powerful people, lots of money was dedicated to studies of both medical error and the outcomes of the claims made for medical error, probably the most of any field of law to be put under such a really fine microscope and to see what it did. So that's that body of research is what I'm going to use as I talk to you today. Can you hear me okay? All right. Put simply, every year, tens of thousands of Americans die because of medical errors. More recent studies put that number in the hundreds of thousands of patients dying every year. Many more suffer serious injury. Very, very few of them make a claim. That's what we've learned. Yet critics claim the system for medical malpractice is out of control. The truth is quite different. The problem is too much malpractice and not too much litigation. In their famous 1999 Institute of Medicine report, the Institute of Medicine, which was and is a very respected mainstream medical organization, published evidence from two big studies that had been done that shocked really the nation and the medical community about the frequency of medical error. And without getting into the weeds too much, they found that just looking at hospital charts, so just inpatient hospital errors, that the number of serious injuries outstripped auto accidents and breast cancer. That the number of deaths nearly totaled the totals from diabetes or Alzheimer's disease. And these were, multiple studies were done. The physicians really didn't believe it. Multiple studies were done in other states. These first two were California and New York, then Utah and Arizona were done. They all came to basically the same conclusion. And they were very conservative in their methodology for obvious political reasons. They wanted to be convincing to their medical peers. And so the physicians who did these studies had two physicians review every chart. And only the chart on which both physicians agreed there was substandard care were treated as medical errors. And cases in which the two physicians were split were treated as good care. So and they wanted to be conservative, and they were, but that made us think, gee whiz, it could be worse if we had a less sympathetic to doctors' orientation. And since then, there have been studies, multiple smaller studies usually, coming to similar or worse conclusions. The most recent, a large one in a very respected journal, the British Medical Journal, researchers from Johns Hopkins just a couple of years ago calculated the numbers and came to the conclusion that medical error, not just in hospitals but throughout the United States, was the third largest cause of death in the United States, following only cancer and heart disease. Their estimate was 250,000 deaths, preventable deaths a year. Other studies have put the numbers as high as 400,000. The job of the American medical malpractice tort civil litigation system is to give those patients access to courts so that if they believe theirs was one of these mishaps and not just an unavoidable accident, that they can have a jury of their peers resolve that dispute. That's what we call open courts. And the United States are known for having open courts. In my state, that separate right is a constitutional right. You cannot erect any law in Missouri that interferes with access to the courts. People have to be able to go to a judge and say, I think I've been wrong. Give me my day in court. And so that's the job of the medical malpractice system. Well, of course, with all these errors, you would think, my gosh, at least the claims that the courts are flooded would be true. But of course, people who work in the field know that's not the case. Multiple studies have found that about 2%, maybe 3% of people caused by medical error file a claim. 2 to 3% file a claim. Now, it's much higher for the people who have serious injuries, but still less than half of the people with serious injuries file a claim. And so that's why I said that the main problem is too much medical error. That's what we would have to fix to reduce medical malpractice litigation. If that's our goal, it's a good goal. Reduce medical error and we'll have less litigation. Now, how do we know these facts? It's important to point out that these aren't numbers that were not manufactured by a lobbying group. They weren't manufactured by plaintiffs' attorneys or by consumer advocates. These were doctors studying other doctors' charts. Right? These numbers that I just used about errors and litigation frequency. Now, of course, that's not the end of the equation. It's important to know for those people who do go to court whether the system's capable of handling their claims fairly. And that's been, if you're old enough to have been around for 20 years, you know that about every 10 years there's been a medical malpractice premium crisis. Premiums have indeed skyrocketed, causing a lot of lament among the healthcare community. They communicated to their legislatures, and as a consequence, the public hears about what waves of litigation, and the claims are often made that they're frivolous claims, but the juries and insurers routinely pay them bags full of money because they're so worried about juries that even claims that have no merit, for care that was perfectly good, for injuries that weren't avoidable, that nonetheless plaintiffs are getting recovery. Well, if that's the message you hear every day, you can understand, if you have friends or family members who are physicians, why they fear being sued like the plague, because they've been told it's a lottery after that. You won't get your day in court. So is that the way things are? In a word, no. In a word, no. And even CRICO is a collaboration of medical malpractice insurers who cover about 30% of the claims in the country. And their participating insurers give them their claims files, their claims data, and they analyze it to try to find patterns that can lead to reduction of risk, reduction of accidents, reduction of payouts. And their conclusion in a 10-year report written in this winter, February, I think, is that malpractice resolutions closely track the quality of care as assessed by other providers. Right? The outcomes closely tracked. This is an insurance company report or insurance trade organization report. Well, another little side note. How do we know this? How is it that we know this? Well, it turns out we know it because the crises of 1976 and 1986 led to grant money being available. And grant money was what was used for social scientists to do this research. And the result is a large body of law about how the civil justice system disposes of cases. So let's take a look at those. I'll start with jury verdicts, because jury verdicts are in some sense the heart of it all. The fear of the jury that's outwitted by plaintiffs' attorneys, that is unable to get over their sympathy for catastrophically injured plaintiffs, and I can tell you that to anticipate something I'll say later about claims shrinking, it's only the most serious claims that can be brought now. It's just so expensive and so low probability to bring a claim that they're the big claims, quite often involving young people with permanent serious disabilities. So you could see how an ordinary jury of peers would be very, very sympathetic, and physicians are understandably worried about that. So what do we know about the outcomes of the system? Well, we don't have slides today, but as a law professor, I need slides. So I'm going to ask you to imagine a slide over here on this screen. And it has 3 columns, right? It's got 3 columns. And the column on the far left has 3 entries. First, it's poor care. That's as determined by some independent physicians reviewing either the claims file or the hospital chart. And by the way, a lot of this data comes from insurance company docs, right? They're hired by insurance companies to review the claims file. And lots of doctors who don't otherwise get involved in malpractice do that. They figure that's sort of their civic duty. They review them, plaintiffs or defendants alike, to say, is there a claim here? So they have these physician reviews. And in a number of studies, they've been divided, and here's your 3 entries. I want you to imagine this. Poor care is the top line. Toss-up care is the middle line. And good care is the bottom line. All right, so you got 3 sets of cases. That's column 1. Column 2, you might think, well, what would be the ideal resolution of these cases if everything were perfect? Well, probably you'd say defendants lose 100% of the poor care cases, they win 50% of the toss-up cases, and they win all of the good care cases. and of course vice versa for the plaintiffs. But we know humans, the doctors reviewing the charts often would disagree with one another in real life. 30% is the usual disagreement rate of physicians reviewing each other's behavior. It's, by the way, the disagreement rate among judges looking at sentencing. It's really kind of one of these odd, sort of unwritten natural laws about human disagreement. And so you expect a fair amount of disagreement, even by people who are pretty well informed, plus the facts that the reviewer looks at and the facts the jury hears won't be identical. New evidence will be determined as of time. Some evidence will be ruled inadmissible. So maybe if you had a really good system, it would be 90% of the good care cases are won by doctors. 90% of the cases rated as poor care by the reviewer would be won by patients, because there's going to be some jury sometimes will disagree reasonably with the physician reviewer, and that the toss-up cases will be 50-50. Because even if there are errors and disagreements, they should balance out in toss-up cases. So you're going to have 90-50-50 would be your second column. Just close your eyes and imagine that slide. And I've got a clicker here. And I'm going to click for you. You guys know about clickers, right? I'm going to click for you the actual numbers that kind of averaging off all the studies that have been done. What percentage of cases do plaintiffs win in the top line, which was poor care cases? Now, I'll call on one of you. Who's up first? I got a volunteer here? What do you predict? What percentage? What? 20%. Whoa, you're a skeptic. Oh, that plaintiffs only win 20% of the cases they should win. Any other guesses? 50% is the right answer. They win half of the cases that independent reviewers say they should win. So juries are more skeptical of plaintiffs and their experts than independent physicians are. Independent physicians don't have to worry about, juries worry about being manipulated. They worry about, how do I decide when two experts are credible? Maybe they insist that the defendant's expert be really so shaky that even they as lay people feel comfortable saying, no, this is a case the plaintiff should win. But when they can't, the tie goes to the doctor. So maybe that's a burden of proof issue too. Maybe they talk about it that way. And they trust doctors. We all trust doctors. Doctors are trusted a lot more than we lawyers are. So you've got 50% plaintiff victory rate there. What about toss-up cases? You want to give a guess? What? Plaintiffs win? Yeah, that's pretty close. They win 30%. They win 30% of the toss-up cases. Defendants win 70% of the toss-up cases. And then how about cases which involve good care in the eyes of a physician reviewer? Doctors win 90%. So they don't win 100%. And when I go through these numbers with some people, they point out right off, well, that 10% error rate would never be accepted in the industry or auto manufacture or whatever. Not looking at the 50% and the 70%, but going straight to the 10%. And that's true. If we thought that the reviewer had all the information and made a perfect decision, and the jury had all the information and made a perfect decision, they would match up at 100% of the wins for the plaintiffs. But humans being what we are, and information being incomplete as it always is when we try to gather what we can for purposes of the trial, 90% is really a damn good rate. It's hard to know a system which would give us a better rate than that. So it turns out that it's worth repeating. Multiple studies of jury outcomes using independent reviewers or preliminary reviews done for liability insurers by their consulting physicians have found that juries favor physicians. So the whole story of juries run amok, at least for physicians, is not true. Well, how about settlements? Settlements, of course, most cases are resolved by settlement or dismissal or dropped. So how about settlements? They're far more in number. Are insurance companies handing out bags of money like candy? And the answer is, of course, no. They're repeat players. They have experience, usually more experienced lawyers than the plaintiffs do. They get the first choice of the local experts who are highly respected. And that all means that when the lawyers are negotiating the strength of the case, the insurance companies have a pretty good idea of what the case is worth. And they estimate settlement value for people who aren't lawyers. That's essentially the odds of a victory at trial versus the anticipated verdict at trials, the dollar amount. And you multiply those two, and you've got a rough account of settlement value. And so that's how claims work. So a lot of cases, it isn't like trial where it's either win or lose. It's always partial. It's always a partial victory for the plaintiff and a partial defeat for the defendant whenever it's not a 0 or 100. But we do know, even though it's messier and harder to evaluate because it has this compromise aspect, that the outcomes are pretty much what you would want to see if you were saying, how should they look? A really good, interesting study by David Studert and Michelle Mello asked the reviewers to be more fine-tuned and to divide up cases on a 6-point scale from almost no evidence or no evidence of subpar care to extremely strong evidence of subpar care. So they had 6 columns. And you would expect in the real world, then what the researchers did is they went to the insurance companies and they said, how many of the cases with number 1 settled? How many of the cases in category number 2 got some money? Any money. How many cases number 3 settled, and so on. And they found that the stronger the case for liability, the more likely the plaintiff would get some money. So it was just, from your direction, it was a little set of stairs. It just went up like this. I mean, as a law professor, when I show it to my students, I was like, this is perfect. I would have drawn one hypothetically to look like this. And that's actually how it worked. In addition, the amount received in each settlement is discounted to reflect the odds of recovery. So there are fewer category 2, some little evidence of negligence cases. They're less often to get $1. Maybe 70 or 80% of those cases, or 70% will get nothing. But when they get something, it's discounted. And some of the studies have said the discounting can be pretty serious. In many cases, it's just forgiving their medical bill, the doctor and hospital medical bill that's outstanding. Sometimes it's enough money to cover for whatever expert fees and the like the plaintiff and the plaintiff's lawyer have expended to prepare for the case. So those are face-saving settlements. So if you take them out, there's still some weak cases that get money, but it's a relatively small group. Most weak cases are dropped by plaintiff's lawyers or dismissed by courts, and so they receive nothing. The correlation between settlement payments and poor care is actually, it is an interesting, unexpected way that's been confirmed, is that just last year or two, there's been some good studies about predictors of future claims. What are good predictors of future claims? And if payments in the past, a settlement payment, if they were random, we would expect them to have no value predicting future claims. But in fact, they're the strongest predictor of future claims. And if you have 2 paid claims, right? Because everybody has access to the court, even if their claim is wrong, no matter how much the plaintiff believes it's true, but they don't get paid anything, it doesn't count. It's like being accused of a crime and acquitted. But if you've paid twice, the odds that you'll be sued again in the future goes up. Now, there are so many doctors who've been sued twice that you can't just charge them all more because most of them won't ever be sued a 3rd time. So that's a problem for the insurance carriers. They can't experience rate just yet, but they're getting there. All right. So that's goal 1. The goal 1 is access to the courts and a just resolution of your claim, providing compensation when compensation is due, and denying it when compensation is not due. Most cases are fuzzy, and some settlement occurs, but it tends to be correlated with the strength of the case and the severity of the injuries. Second major goal of tort law, I'm getting close, aren't I? Where's the 5 minutes? Second major goal of tort law is to deter future accidents and injuries and force people to stay sharp because otherwise they'll get sued. Critics say, with some theoretical reason, that when people have good insurance, like medical malpractice insurance, then they don't have to be careful anymore because insurance premiums are not experience rated. It's not like a driver. If drivers didn't have their premiums go up, would they have any incentive to be careful to keep their premiums down? No. So that's the claim by the critics. But it turns out that there is something to that, but it overlooks a whole host of other ways that tort law makes our medical care more safe. The first, and one I think that's really, really important and never mentioned, is that malpractice litigation literally supercharged the modern patient safety movement. The modern patient safety movement, those were doctors who just believed in patient care should be better, and that they should get better every year, just like General Electric's quality improvement theories. But they weren't getting a lot of mileage, a lot of traction within their field because doctors said, well, we're doing it right. So rest, take it easy. Don't tell me how to practice. Don't give me guidelines in cookbook medicine. And then 2 massive studies were done that I mentioned to you that showed that errors were very, very common. Every time 100 people went into a hospital, 1 person came out with an injury caused by subpar care. And, okay, so what does that got to do? Why should tort law take credit? And those studies gave ammunition to the patient safety movement. Now they were able to say, hey, the Institute of Medicine says we have serious work to do to reduce mishaps, to come up with systems that catch human error, because humans make errors. They catch human errors more quickly, just like the Japanese car makers did, using continuous quality improvement back in the 60s and 70s and beat the pants off of Detroit for 20 or 30 years before Detroit caught up. So that was their theory, but they had the ammunition. And so why do I say tort law should take some credit for that? Well, because those 2 big studies that provided the data were done only because doctors were infuriated by the rising amount of medical malpractice premiums. That's what prompted it. The tort litigation system prompted the study, prompted them to say, what the heck's going on here? Things are bad in court, what the heck's going on? Those would never have been done. And in fact, the first of those was done in California. It was sponsored by the California Medical Society. Their goal was to show errors are rare and litigation is common. And guess what? They found just the opposite. That study was never published, but it wasn't burned, so eventually people found it, but it never got submitted for publication. So that's point number 1. Point number 2, tort rules themselves have been shown to increase patient safety. They used to have a rule that doctors were governed by local practices. That was changed in the second half of the 20th century to say doctors are governed by natural practice, natural and national practices. A recent study found, looking at big data, crunching big data, that health quality improved as states moved from the locality standard to the national standard. Health outcomes, patients' welfare improved. All right. Third, individual cases changed physician behavior. Some famous cases, like the one on glaucoma screening, immediately led to more glaucoma screening younger in life by eye doctors. We know others too. Any lawyers who've been doing med and mal at all will know there are some doctors who, after getting sued a couple of times, either their insurer said, we're not covering you for that procedure anymore, or the hospital said, you're not going to have privileges to do that procedure anymore. Again, patients' safety improved. Fourth, physicians have a stark fear of being sued. And so, whether they're covered by insurance or not, they will avoid practices like the plague that they think will keep them from being sued. They just have been convinced that doing good medicine isn't the best route to get there. And that's part of our job, probably, is to do a better job of making that clear to them. Fifth, liability insurers have a strong incentive to encourage doctors to be careful, even if they aren't adjusting premiums. They kick doctors off of coverage individually. If it's a group plan, they raise the group plan rate. So there are a variety of ways that insurance companies put pressure on groups not to keep the frequent flyers. And then finally, malpractice insurers help physician specialties create better guidelines. The patient safety movement hoped to do that initially with internal communications. And they asked for, and got, special legislation to make communications confidential. They asked for and got, I'll stop there. So at any rate, internal communication was supposed to be the way that that information about bad outcomes and near misses got collected. And then doctors would analyze that data and learn the lessons. It's great. I mean, it's perfect. Good strategy. But there are all kinds of obstacles within a healthcare organization for asking anybody to say, hey, I goofed up yesterday. That would be true of us as lawyers, too. If they said, okay, from now on in your firm, you goof one up, first thing you go to the managing partner and you say, hey, I goofed one up. So that's not been a great source of information. It turns out the files of medical malpractice carriers are being used by medical associations to learn the lessons of bad outcomes. It's not a random sample, that's for sure, but it is a sample of ones that were serious and disputed. And so anesthesiology used closed claims files to drop mortality rates, not just claims, mortality rates from 1 in 20,000 to 1 in 250,000. A tenfold drop in mortality using closed malpractice claims at Harvard's 8 hospitals. Obstetrics has used it on a smaller scale, 44% drop in medical obstetrics claims over the last 10 years. So to the extent that any quality improvement is being done, claim information generated by the tort system is providing the raw material for it. So there are lots of reasons to believe that tort law has helped to make the delivery of medical care more safe. I'll skip frivolous claims and defensive medicine. You all can read that in the paper that I post later, but I want to make one final comment, and that's, or two. One is that claims are plummeting, 23 per 1,000 physicians in 1991, 8 per 1,000 physicians in 2018. So to the extent that underclaiming is a problem, it's getting worse. And then secondly, the best way to get better care, a better climate is to reduce errors. And I want to quote Dr. Aaron Carroll. This is my last paragraph. Dr. Aaron Carroll, a pediatrician at the University of Indiana who writes frequently on medicine for the New York Times. This is his language. Too often, efforts to fight undeniable problems in the malpractice system start from the assumption that there are too many cases, that they're not real, and that we need to come up with solutions to limit them. But what the data suggest is that improving medical practices may be a much more effective approach than passing new laws. Thank you.
Well, that's cool, isn't it?